or implied, and I have not given him any, other than that I would run the department with professionalism and integrity. As Attorney General, my allegiance will be to the rule of law, the Constitution, and the American people. This is how it should be, this is how it must be, and if you confirm me, this is how it will be. Now let me address a few matters I know are on the minds of some of the members of this committee. First, I believe it is vitally important that the special counsel be allowed to complete his investigation. I have known Bob Mueller for 30 years. We worked closely together throughout my previous tenure at the Department of Justice. We've been friends since, and I have the utmost respect for Bob and his distinguished record of public service. And when he was named special counsel, I said his selection was good news, and that knowing him, I had confidence he would handle the matter properly, and I still have that confidence today. Given his public actions to date, I expect that the special counsel is well along in his investigation. At the same time, the president has been steadfast that he was not involved in any collusion with Russian attempts to interfere in the election. I believe it is in the best interest of everyone, the president, Congress, and the American people, that this matter be resolved by allowing the special counsel to complete his work. The country needs a credible resolution to these issues. And if confirmed, I will not permit partisan politics, personal interests, or any other improper consideration to interfere with this or any other investigation. I will follow the special counsel regulations scrupulously and in good faith, and on my watch, Bob will be allowed to finish his work. Second, I also believe it is very important that the public and Congress be informed of the results of the special counsel's work. My goal will be to provide as much transparency as I can consistent with the law. I can assure you that where judgments are to be made, I will make those judgments based solely on the law, and I will not let personal, political, or other improper interests influence my decision. Third, I would like to briefly address the memorandum that I wrote last June. I wrote the memo as a former Attorney General who has often weighed in on legal issues of public importance, and I distributed it broadly so that other lawyers would have the benefit of my views. My memo was narrow, explaining my thinking on a specific obstruction of justice theory under a single statute that I thought, based on media reports, the special counsel might be considering. The memo did not address or in any other way question the special counsel's core investigation into Russian efforts to interfere in the election, nor did it address other potential obstruction of justice theories or argue that some have wrongly suggested that a president can never obstruct justice. I wrote it myself, on my own initiative, without any assistance, and based solely on public information. I would like to comment very briefly on my priorities if confirmed as Attorney General. First, we must continue the progress we've made on violent crime, while at the same time recognizing the changes that have occurred since I last served as Attorney General. The recently passed First Step Act, which I intend to diligently implement if confirmed, recognizes the progress we have made over the past 3 decades in fighting violent crime. As Attorney General, I will ensure that we will continue our efforts to combat violent crime. In the past, I was focused on predatory violence, but today I am also concerned about another kind of violence. We can only survive and thrive as a nation if we are mutually tolerant of each other's differences, whether they be differences based on race, ethnicity, religion, sexual orientation, or political thinking. And yet we see some people violently attacking others simply because of their differences. We must have zero tolerance for such crimes, and I will make this a priority as Attorney General if confirmed. Next, the Department will continue to prioritize enforcing and improving our immigration laws. As a nation, we have the most liberal and expansive immigration laws in the world. Legal immigration has historically been a huge benefit to this country. However, as we open our front door and try to admit people in an orderly way, we cannot allow others to flout our legal system by crashing in through the back doors. In order to ensure that our immigration system works properly, we must secure our nation's borders, and we must ensure that our laws allow us to process, hold, and remove those who unlawfully enter. Finally, in a democracy like ours, the right to vote is paramount. In a period of great political division, one of the foundations of our nation is our enduring commitment to the peaceful transition of power through elections. If confirmed, I will ensure that the full might of our resources are brought to bear against foreign persons who unlawfully interfere in our elections. Fostering confidence in the outcome of elections also means ensuring that the right to vote is fully protected, as well as ensuring the integrity of elections. Let me conclude by making the point that over the long run, the course of justice in this country has more to do with the character of the Department of Justice as an enduring institution than with the tenure of any particular Attorney General. Above all else, if confirmed, I will work diligently to protect the professionalism and integrity of the department as an institution, and I will strive to leave it and the nation a stronger and better place. Thank you very much for your time today, and I look forward to answering your questions.
You've been watching the confirmation hearing for William Barr, President Trump's nominee for the next Attorney General. This will continue live on Capitol Hill. Please stay tuned to Fox News Channel and this Fox station for continuing coverage of this story. For Sandra Smith and Bill Hemmer in New York, thank you for joining us.
Eminent sense to me. Once you go down that road, then the rule of law collapses. But there's another side to this equation, if I may say a two-way street. What about those in charge of enforcing the law? What about those with the power to bring charges against American citizens, including people up here? I remember Senator Stevens' case in Alaska. So we should always be on guard about the politician interfering in an investigation, but we should also have oversight of how the department works and those with this tremendous power use that power. Are you familiar with the January 11th New York Times article about FBI open inquiry into whether Trump was secretly working on behalf of Russians?
Yes, Mr. Chairman.
Would you promise me and this committee to look into this and tell us whether or not, in the appropriate way, a counterintelligence investigation was opened up by somebody at the FBI/Department of Justice against President Trump?
Yes, Mr. Chairman, I think there are a number of investigations, as I understand it, going on in the department.
Have you ever heard of such a thing in all the time you've been associated with the Department of Justice?
I have never heard of that.
Are there rules about how you can do counterintelligence investigations?
I believe there are, Mr. Chairman.
So if you want to open up one against the president, are there any checks and balances?
Not outside the FBI.
Okay, well, we need to look at that. In terms of people who are actually enforcing the law, don't we want to make sure they don't have an agenda?
That's right, Mr. Chairman.
Do you know a Lisa Page or Peter Strzok?
I've heard their names.
But do you know them personally?
No, I don't.
This is a message, August 8th, 2016, a text message. Trump's not ever going to become president, right? Right. Strzok responded, no, he's not. We'll stop him. Strzok was in charge of the Clinton email investigation. Ms. Page worked at the Department of Justice. August 15th, 2016. I want to believe the path you threw out for consideration in Andy's office, that there's no way he gets elected, but I'm afraid we can't take that risk. It's like an insurance policy in the unlikely event you die before 40. March 4th, 2016. Page to Strzok. God, Trump is a loathsome human being. October the 20th, 2016. Trump is an effing idiot, is unable to provide a coherent answer. To all those who enforce the law, you can have any opinion of us that you like, but you're supposed to do your job without an agenda. Do you promise me as Attorney General, if you get this job, to look in to see what happened in 2016?
Yes, Mr. Chairman.
How do these statements sit with you?
I was shocked when I saw them.
Okay, please get to the bottom of it. I promise you we will protect the investigation, but we're relying upon you to clean this place up. FISA warrants, are you familiar with a FISA warrant?
Yes, Mr. Chairman.
Okay. During the process of obtaining a warrant, is there a certification made by the Department of Justice to the court that the information being provided is reliable?
Yes, sir.
Are you familiar with Bruce Orr?
No, I'm not.
Bruce Orr was Associate Deputy Attorney General for Organized Crime and Drug Enforcement. His wife worked at Fusion GPS. Are you familiar with Fusion GPS?
Yes, I've read about that.
Fusion GPS, Mr. Barr, was hired by the Democratic National Committee and the Clinton campaign to do opposition research against candidate Trump and maybe other candidates. But we now know that they hired Fusion GPS, Michael Steele, who is a former British agent, to do opposition research and produce the famous dossier. Were you aware that Mr. Orr's wife worked for that organization?
I've read that.
Does that bother you if he had anything to do with the case?
Yes.
Are you aware that on numerous occasions he met with Mr. Steele while his wife worked with Fusion GPS?
I've read that.
Okay. The warrant certification against Carter Page on 4 different occasions certifies that the dossier, which was the main source of the warrant, was reliable. Would you look in to see whether or not that was an accurate statement and hold people accountable if it was not?
Yes, Mr. Chairman.
Mueller. You say you've known Mueller a long time. Would you say you have a close relationship with Mr. Mueller?
I would say we were good friends.
Would you say that you understand him to be a fair-minded person?
Absolutely.
Do you trust him to be fair to the president and the country as a whole?
Yes.
When his report comes to you, will you share it with us as much as possible?
Consistent with the regulations and the law, yes.
Do you believe Mr. Mueller would be involved in a witch hunt against anybody?
I don't believe Mr. Mueller would be involved in a witch hunt.
What are the circumstances that would allow a special counsel to be appointed, generally speaking?
Well, I appointed 3, Mr. Chairman, a special counsel, and generally, when something comes up, an issue comes up that needs to be investigated, and there are good reasons to have it investigated by a special counsel outside the normal chain at the department, someone usually of public stature that can provide additional assurance of nonpartisan.
Do you believe that Attorney General Sessions had a conflict because he worked on the Trump campaign?
I'm not sure of all the facts, but I think he probably did the right thing recusing himself.
I agree. I think he did the right thing to recuse himself. Do you know Rod Rosenstein?
Yes, I do.
What's your opinion of him?
I have a very high opinion of Rod Rosenstein and his service in the department.
Okay. Why did you write the memo?
I wrote the memo because starting, I think, in June of 2017, there were many news reports, and I had no facts, and none of us really outside the department have facts. But I read a lot of news reports suggesting that there were a number of potential obstruction theories that were being contemplated, or at least explored. One theory in particular that appeared to be under consideration under a specific statute concerned me because I thought it would involve stretching the statute beyond what was intended and would do it in a way that would have serious adverse consequences for all agencies that are involved in the administration of justice, especially the Department of Justice. And I thought it would have a chilling effect going forward over time. And my memo is very clear. That is the concern that was driving me. The impact, not the particular case, but its impact of a rule over time. And I wanted to make sure that before anyone went down this path, if that was in fact being considered, that the full implications of the theory were carefully thought out. So I wanted my views to get in front of the people who would be involved in, and the various lawyers who would be involved in those discussions. So I first raised these concerns verbally with Rod Rosenstein when I had lunch with him early in 2008, and he did not respond and was sphinx-like in his reaction, but I expounded on my concerns. And then I later attempted to provide a written analysis as follow-up. Now, I initially thought of an op-ed, and because of the material, it wasn't working out, and I talked to his staff, and I said, I want to follow up and send something to Rod in writing, but is he a one-pager kind of guy, or how much will he read? And the guy said, he's like you. He doesn't mind wading into a dense
Don't you think
memo.
President Trump is a one-pager kind of guy?
Excuse me?
President Trump is a one-pager kind of guy.
I suspect he is.
Okay, just remember that. Go ahead.
Yeah. And so I provided the memo to Rod, and I provided it, distributed it freely among the other lawyers that I thought would be interested in it. And I think it was entirely proper. It's very common for me and for other former senior officials to weigh in on matters that they think may be ill-advised and may have ramifications down the road. For example, just a few months before that, I had weighed in repeatedly to complain about the idea of prosecuting Senator Menendez. I think I made 3 calls. I think it was 2 to Sessions, to AG Sessions, and 1 to Rosenstein. Now, I didn't know Senator Menendez. I don't represent Senator Menendez. No one was paying me to do it. And in fact, I don't support Senator Menendez politically. But I carefully watched this case. My friend Abby Lowell was his defense counsel, and it was very much like a line of cases that I had been concerned about when I was AG, and so I was watching it, and I thought the prosecution was based on a fallacious theory that would have bad long-term consequences, and so I freely weighed in at the department. And I did so because I care about the rule of law. And I want to say one final thing on the rule of law because it picks up on something you said, Mr. Chairman. What is the rule of law? We all use that term. In the area of enforcement, I think the rule of law is that when you apply a rule to A, it has to be the same rule and approach you apply to B, C, D, and E, and so forth. And that seems to me to suggest 2 corollaries for an attorney general. The first, that's why we don't like political interference. Political interference means that the rule being applied to A isn't the rule you're applying to A. It's special treatment because someone's in there exerting political influence. The corollary to that, and this is what you're driving at, Mr. Chairman, is that when you apply a rule, when a prosecutor is applying a rule to A, you've got to be careful that it's not torqued, especially for that case, in a way that couldn't be applied down the road, or if it is applied, will create problems down the road. And I think the Attorney General's job is both. It is both to protect against interference, but it's also to provide oversight to make sure that in each individual case, the same rule that would be applied broadly is being applied to the individual.
Thank you, Mr. Chairman. 6 quick yes or no questions. Will you commit to no interference with the scope of the special counsel's investigation?
I will. The scope of the special counsel's investigation is set by his charter and by the regulations, and I will ensure that those are maintained.
Will you commit to providing Mr. Mueller with the resources, funds, and time needed to complete his investigation?
Yes.
Will you commit to ensuring that Special Counsel Mueller is not terminated without good cause, consistent with department regulations?
Absolutely.
If Special Counsel Mueller makes any request, for instance, about the scope of his investigation or resources for his investigation, will you commit to notifying Congress if you deny that request?
I think the regulations require notification of Congress if there's a disagreement.
Thank you. And I have 2 questions from the chairman of the House Judiciary Committee. Will you commit to making any report Mueller produces at the conclusion of his investigation available to Congress and to the public?
As I said in my statement, I am going to make as much information available as I can, consistent with the rules and regulations that are part of the special counsel regulations.
Will you commit to making any report on the obstruction of justice public?
That's the same answer.
Thank
Yes.
you. In your June 2018 memo about obstruction of justice to the Mueller investigation, you repeatedly referred to Mueller's, quote, sweeping and all-encompassing interpretation of Section 1512, which is a statute on obstruction. How do you know what Mueller's interpretation of 1512 is?
Well, as I said, I was speculating. I freely said at the beginning, I was writing in the dark, and we're all in the dark. Every lawyer, every talking head, everyone who thinks about or talks about it doesn't have the facts.
So I spent my Saturday reading that memorandum.
Yeah.
So are you saying this is all your speculation? It's a big memo.
Well, it was informed to the extent that I thought that was one of the theories being considered. And I don't know how seriously, whether it was being considered or how seriously it was being considered. But as a shorthand way in the memo of referring to what I was speculating might be the theory, I referred to it as Mueller's theory, rather than go in every time I mention it, say, well, this is speculative.
Do you know what Mueller's interpretation of 1512 is?
No, I don't know what Mueller's interpretation. Okay. But, and just one point, Senator, I think, you said in your opening statement, I said he was grossly irresponsible. I think I said if something happens, it would be grossly irresponsible. I was not calling Mueller grossly irresponsible.
I understand. Thank you.
Okay.
I appreciate that. Has anyone given you non-public information about Mueller's investigation?
I don't recall getting any confidential information about the investigation.
Your 2018 in it, you stated, and I quote, "The framers' plan contemplates that the president's law enforcement powers extend to all matters, including those in which he had a personal stake," end quote. Please explain what you base this conclusion on.
Yes. Here's the Department of Justice right here. And within the Department of Justice, enforcement decisions are being made. The president's over here. And I think of it as there are two categories of potential communications. One would be on a case that the president wants to communicate about that he has no personal interest in, no political interest in. Let's say the president's concerned about Chinese stealing trade secrets and say, I want you to go after this company that's being, that may be stealing trade secrets. That's perfectly appropriate for him to do, to communicate that. But whether it's bona fide or not, the Department of Justice's obligation and the Attorney General's obligation is not to take any action unless the Department of Justice and the Attorney General, reach their own independent conclusion that it is justified under the law, and regardless of the instruction. And that's my quote that everyone is saying, I'm sicking, it's okay for the president to direct things. All I said was, it's not per se improper for the president to call on the department for doing something, especially if he has no personal or political interest in it. The other category of cases, and let's pick an easy bad example, would be if a member of the president's family or a business associate or something was under investigation and he tries to intervene. He's the chief law enforcement officer, and you could say, well, he has the power, but that would be a breach of his obligation under the Constitution to faithfully execute the laws. So, in my opinion, if a president attempts to intervene in a matter that he has a stake in to protect himself, that should first be looked at as a breach of his constitutional duties. Whether it also violates a statute, depending on what statute comes into play and what all the facts are.
including the emollients clause of the Constitution?
Well, I think there's a dispute as to what the emoluments clause relates to. I have not personally researched the emoluments clause. I can't even tell you what it says at this point. Off the top of my head, I would have said, well, emoluments are essentially a stipend attached to some office, but I don't know if that's correct or not. But I'm sure, I think it's being litigated right now.
I don't know either, so I'm going to try and find out. We'll come back another day and maybe discuss it. Your memo stated a fatal flaw in Mueller's interpretation of 1512C2 is that while defining obstruction solely as acting corruptly, Mueller offers no definition of what corruptly means. My understanding is that there's nothing in the public record that sheds light on his definition of obstruction. Do you know what his definition is?
I don't know what his definition is. I read a book where people were asking whether someone was, I don't know if it was accurate, but whether the president was acting with corrupt intent. And what I say in my memo is actually, people don't understand what the word corruptly means in that statute. It's an adverb, and it's not meant to mean with the state of mind. It's actually meant the way in which the influence or obstruction is committed. That's its adverbial function in the statute. And what it means is, using it in the 19th century sense, it meant to influence it in a way that changes something that's good and fit to something that's bad and unfit, namely the corruption of evidence or the corruption of a decision maker. That's what the word corruptly means, because once you dissociate it from that, it really means very hard to discern what it means. It means bad. What does bad mean?
Let me go on because my time is so limited. You argue that and I quote, the Constitution's plenary grant of those powers to the president also extends to the unitary character of the executive branch itself. Specifically, you argue, and this is a quote, while Mueller's immediate target is the president's exercise of his discretionary powers, his obstruction theory reaches all exercises of prosecutorial discretion by the president's subordinates, from the attorney general down to the most junior line prosecutor, end quote. So if the president orders the attorney general to halt a criminal investigation for personal reasons, would that be prohibited under your theory?
Prohibited by what?
By
the Constitution.
The Constitution.
I think it would be a breach of the president's duties to faithfully execute the law. It'd be an abuse of power. Whether it would violate a statute depends on all the facts and what statute someone would cite me to. But I certainly think it would be an abuse of his power. And let me just say that the position...
Would that be the same thing if an attorney general fired U.S. attorneys for political reasons?
No, because U.S. attorneys are political appointments.
According to news reports, President Trump interviewed you and asked you to be part of the legal team defending him in the Mueller investigation twice. First in the spring of 2017, when the investigation was just beginning, and again earlier this year. Is that correct?
No. I had one conversation with him that related to his private representation. I can describe that for you. That was in June of 2017. That's the only time I met him before I talked to him about the job of Attorney General, which obviously is not the same as representing him.
Have you discussed the Mueller investigation with the president or anyone else in the White House?
I discussed the Mueller investigation, but not in any particular substance. I can go through my conversations with you if you want.
Well, not at this time, but I may come back to you and ask you about that. I don't want to take any more time. Thank you, Mr. Chairman.
Each senator gets about 10 minutes, and that questioning from Senator Feinstein from California really went to the memorandum that was written back in June of 2018, so 7-8 months ago, in which William Barr made the case in 19 pages of a written memo about an obstruction theory that he felt was off on behalf of Bob Mueller, and that's why the questioning is coming from that angle. We are going to take a 60-second timeout. We just want to get this commercial in here, then we'll get ready for Chuck Grassley coming up next. Stand by.
This is PillPack. It's my new pharmacy. Now I have my medications.
Now questioning the AG nominee William Barr on Capitol Hill. Let's listen back in.
Money lost to fraud. Since 1986, the law that was passed in 1986 brought in $56 billion into the federal treasury. Most of that's because patriotic whistleblowers found the fraud and brought the case to the attention of the government. Is the False Claims Act unconstitutional?
No, Senator. It's been upheld by the Supreme Court.
Do you consider the False Claims Act to be an abomination?
No, I don't.
Does the False Claims Act benefit the taxpayer, specifically its provisions to empower and protect whistleblowers?
Yes, Senator.
If confirmed, do you commit to not take any action to undermine the False Claims Act? Further, if confirmed, will you continue current Justice Department staff and funding levels to properly support and prosecute False Claims Act cases?
Yes, I will diligently enforce the False Claims Act.
Now, with all those positive answers, you'd think I'd be done, wouldn't you, with that? But let me go on. Yeah, just to show you that there is some forces out there that I'm suspicious about within the Department of Justice. We have a new Department of Justice guidance document out last year, known as the Granston Memo, provides a long list of reasons that the department can use to dismiss False Claims Act cases, some of them pretty darn vague, such as preserving, these are their words, preserving government resources. Just think of all the mischief those three words can bring. Of course, the government can dismiss, obviously, meritless cases. I don't argue with that. But even when the department declines to participate in False Claims Act cases, the taxpayer can, in many cases, still recover financially. So it's important to allow whistleblowers to pursue cases even when the department isn't able to be involved. Under what circumstances can or should the Justice Department move to dismiss false claims cases?
Senator, I haven't reviewed that memorandum, so I'm not familiar with the thinking of the people in this. I think it's the Civil Division that did that, but if I'm confirmed, I will review it, and I would be glad to come and sit down with you and discuss it, and if there are areas you're concerned about, I'd be glad to work with you on that.
Unless you find that my presumption is wrong, that there's reasons to be suspicious, I hope you'll take into consideration my feeling about how, in various suspicious ways, people that are faceless bureaucrats can undermine this effort. In circumstances where the government doesn't intervene in false claims cases, if confirmed, will you commit to ensuring the department doesn't unnecessarily dismiss false act cases?
Yes, Senator, I will enforce the law in good faith.
Okay. Now, got an act that the Justice Department just took, and I can't obviously expect you to respond specifically to their act, but I use it as an example of their uncooperation with the Department of Congressional Oversight. This uncooperative behavior needs to change. On December the 10th last year, the department confirmed a briefing for your staff regarding asset forfeiture fund, and to do that last week, January the 8th. On January the 7th, Department of Justice Office of Legal or Legislative Affairs informed our staff that they will no longer provide the briefing because they consider the matter closed as a result of the change in chairmanship and because you released a public memo, because I released a public memo on the Marshal Service study or investigation. It's important to gain your commitment on how you would handle this as an example. Let me explain how ridiculous it is to get somebody in this administration saying that they don't have to answer if you aren't chairman of a committee. We went through this in January, the first month this president was in office, when he said, or he put out a memo, we aren't going to answer any oversight except for chairman of committees. So you're going to write off 500 members of Congress not doing oversight. So we told them all about this and the constitutional cases on this. We got them up. They wrote a memo again 2 months later that said that they were going to respond to all this stuff. Now you got people in the bowels of the bureaucracy that are still saying, if you aren't a chairman, you ain't going to get an answer to anything. How ridiculous. It's our constitutional responsibility. So then I laid out, I'll give you an example. I sent the Justice Department a classified letter regarding information acquired from the Justice Department Inspector General report on the Clinton investigation. The department ought to answer for what the Inspector General has found, but I haven't heard a peep, not a peep, on that yet. On December the 10th, the Justice Department, well, I'm repeating here. So the question is, do you understand that if you're confirmed, you have an obligation to ensure the Justice Department, and particularly the FBI is a problem, respond to congressional inquiries and to do it in a timely manner?
Absolutely, Senator.
You understand that this obligation applies regardless of whether you're a member of Congress or a committee chairman?
Yes, Senator. You and Senator Leahy, I think, are the only members of the committee now who were here 27 years ago when I was first confirmed. But I think you will recall that we were able to establish very cooperative and productive relationships with all the members and try to respond to their questions and deal with their concerns and work with them on projects they're interested in. And that will be the same approach that I will bring to the job if you confirm me.
Okay. Then let me be specific on my last question on oversight. You remember when you were in my office, I gave you, as I gave Attorney General Sessions, as I gave Holder, a long list of things that the department has not answered. And one of these was an October 17, 2018 letter. And I'd like to have your response to answering that letter and respond to all outstanding and future oversight requests in a timely manner. And then remember, I said, all you cabinet people come up here to tell us yes when we ask you if you're going to answer our stuff. I said, maybe you better say maybe. So if you want to say maybe now and be really honest, say maybe. Otherwise, I hope you'll answer that October 17th letter once we get you voted into office.
Yes, Senator.
Throughout your career, you've expressed concern with congressional attempts to enact criminal justice reform and at times advocated for stricter mandatory minimum sentences. In '92, under your direction, DOJ published a report entitled The Case for More Incarceration. This report declared that the problem with our criminal justice system was that we were incarcerating too few criminals. More recently, in 2015, you signed a letter opposing the Sentencing Reform and Corrections Act of 2015. This letter states quite clearly your opposition to sentencing reform, particularly the lessening of mandatory minimum sentences, any sort of retroactivity. The First Step Act was signed by President Trump. As Attorney General, it'll be your job to implement the legislation. Even though you've opposed criminal justice reform in the past, will you commit to fully implementing the First Step Act?
Yes, Senator. But in 1992, when I was Attorney General, the violent crime rates were the highest in American history. The sentences were extremely short. Typically, in many states, the time served for rape was 3 years. For murder, time served 5 to 7 years. It was, the system had broken down. And I think through a series of administrations, Reagan, Bush, and Clinton, the laws were changed. And we targeted chronic violent offenders, especially those using guns. And I think the reason the crime rate is much lower today is because of those policies. So I don't think comparing the policies that were in effect in 1992 to the situation now is really fair. And I think, and I've said that right now we have greater regularity in sentencing. There's broader recognition that chronic violent offenders should be incarcerated for significant periods of time to get them off the streets. And I think the time was right to take stock and make changes to our penal system based on current experience. So I have no problem with the approach of reforming the sentencing structure. And I will faithfully enforce that law.
Don't take it personal if I raise my voice to you. I'm not mad at you.
If I were you, I'd answer his letters just as sort of a tip that may help you through your job if you get it. I'll take the time away from my second round. I'm very curious about the conversations you had.
I will
about
enforce the
personal
law in
representation.
good faith. You've been listening to the AG nominee, William Barr, answering questions from Chuck
Yeah, so in
Grassley from
June
Iowa.
of
This will continue. We're going to
middle
take
of
a quick
June,
break, 1 minute, and we'll be right back.
Ambassador David Friedman, who's the U.S. ambassador.
I love you, Dad.
A what?
Near the commercial there about why
not
he
have any
at first did not want the job. In fact, in his prepared comments, he ad-libbed this line. In fact, I proposed a number of other candidates. Nonetheless, here he is in the hot seat, back inside now. The questioning
My
continues.
wife and I were sort of looking forward to a bit of respite, and I didn't want to stick my head into that meat grinder. He asked me if I would nonetheless meet, just briefly go over the next day to meet with the president. And I said, sure, I'll go and meet with the president. And he brought me over and was squeezing me in. It looked to me like it was before the morning staff meeting because people were grouping by the door to get in, and I went in. And he was there, the ambassador was there, sat through the meeting. It was a very brief meeting where essentially the president wanted to know, he said, oh, you know Bob Mueller. How well do you know Bob Mueller? And I told him how well I knew Bob Mueller and how, the Barrs and Muellers were good friends and would be good friends when this is all over and so forth. And he was interested in that, wanted to know, what I thought about, Mueller's integrity and so forth and so on. And I said, Bob is a straight shooter and should be dealt with as such. And, he said something to the effect like, so are you envisioning some role here? And I said, actually, Mr. President, right now I couldn't do it. My personal and my professional obligations are such that I'm unable to do it. So he asked me for my phone number. I gave it to him, and I never heard from him again until.
Well, I tried that once. You did better.
Well, I didn't hear from him until, later, but about something different, which was the Attorney General position.
Thank you, Mr. Barr. Good to see you again. As you mentioned, Senator Grassley and I were here at your hearing a number of years ago. Let me go back even before that. 46 years ago, I was not in the Senate. I was state's attorney in Vermont, and I watched with a great deal of interest the Elliot Richardson hearings. He'd been nominated to be Attorney General at the midst of Watergate. He made several commitments to the committee, including appointing a special prosecutor, and he promised to protect his independence. And I, as one who had total independence as an elected prosecutor in Vermont, I thought how important it was to have that same independence at the national level. And Mr. Richardson said it was necessary to create the maximum possible degree of public confidence in the integrity of the process. I've never forgotten that. I think the integrity of our institutions is just as much at risk today. President Trump has made it clear he views the Justice Department as an extension of his political power. He's called on it to target his opponents. He obsesses over the Russia investigation, which looms over his presidency, may define it. He attacks the special counsel almost daily. He fired both the previous FBI director and attorney general for not handling the investigation as he pleased. That tells me the rule of law can no longer be taken for granted. So if confirmed, the president's going to expect you to do his bidding. I can almost guarantee you, he'll cross the line at some point. That's why the commitments you make here today, just like those I watched Elliot Richardson make years ago, matter greatly. So will you commit, if confirmed, to both seeking and following the advice of the department's career ethics officials on whether you must recuse from the special counsel's investigation?
I will seek the advice of the career ethics personnel, but under the regulations, I make the decision as the head of the agency as to my own recusal. So I certainly would consult with them, and at the end of the day, I would make a decision in good faith based on the laws and the facts that are evident at that time.
Same thing if you're talking about a conflict of interest?
Well, no, some conflicts, as you know, are mandatory.
I'm thinking what Attorney General Sessions, and when asked a similar question, he said he'll seek and follow the advice of the Department of Justice's designated ethics officials. So let me ask you, maybe in a different way. I know you promised to not interfere with the special counsel. Are there any circumstances that would cause you to terminate the investigation or any component of it, or significantly restrict its funding?
Under the regulations, Bob Mueller could only be terminated for good cause, and frankly, it's unimaginable to me that Bob would ever do anything that gave rise to good cause. But in theory, if something happened that was good cause, for me, it would actually take more than that. It'd have to be pretty grave, and the public interest would essentially have to compel it, because I believe right now the overarching public interest is to allow him to finish.
I would agree with that, but I also think over the past 18 months, you rather harshly prejudged the investigation in some of your writings.
Well, I don't see that at all, Senator. You know, when you strip away a lot of the rhetoric, the two things that have been thrown up as me sort of being antagonistic to the investigation are two things. One, a very mild comment I made that, gee, I wish the team had been more balanced. I wasn't criticizing Mueller. I believe that prosecutors, and I think you would agree, they can handle the case professionally, whatever their politics are. A good prosecutor can leave their politics at the door and go in and do the job. And I think that's what Justice Department prosecutors do in general.
But you also are very critical of the Russian probe. And I can't think of anything that would, in your memo, for example, that would jump out more for this president because of his commitment to it. And I ask that because some have said, on both sides, that it looked like a job application. And so that's what I want you to refer to.
That's ludicrous. If I wanted the job and was going after the job, there are many more direct ways of me bringing myself to the president's attention than writing an 18-page legal memorandum, or sending it to the Department of Justice and routing it to other.
But also publicly criticizing the Russian probe. I mean,
how have I criticized the Russian probe?
You don't have any criticism of the Russian probe?
Not at all. I believe the Russians interfered or attempted to interfere with the election, and I think we have to get to the bottom of it.
So you would be in favor of releasing the investigative report when it's completed?
As I've said, I'm in favor of as much transparency as there can be, consistent with the rules and the law.
Do you see a case where the president could claim executive privilege and say that parts of the report could not be released?
Well, I don't have a clue as to what would be in the report. The report could end up being, not very big. I don't know what's going to be in the report. In theory, if there was executive privilege material to which an executive privilege claim could be made, it might, someone might raise a claim of executive privilege.
That'd be pretty difficult following U.S. versus Nixon when the Supreme Court unanimously rejected President Nixon's claims of executive privilege over the Watergate tapes. But I ask it because the president's attorney, Mr. Giuliani, said the president should be able to correct the Mueller report before any public release. So in other words, he could take this investigative report, put his own spin on it, and correct it before it's released. You commit that would not happen if you were Attorney General?
That will not happen.
Thank you. You had, when you're AG, I remember this well because I was here in the Senate at the time, you encouraged President George H.W. Bush to pardon all 6 individuals who were targeted in Iran-Contra. The independent prosecutor investigating the matter labeled that a cover-up. Now, you and I talked about this in my office, and I appreciate you coming by. I found the conversation the two of us had be well worthwhile. Do you believe a president could lawfully issue a pardon in exchange for the recipient's promise to not incriminate him?
No, that would be a crime.
Thank you. In 1990, you argued that Congress appropriation power is not an independent source of congressional power to control the allocation of government resources. There are only 3 committees in the Senate to have a vice chairman. Appropriation is one of them. Obviously, as vice chairman, I kind of looked at that. You claim that if a president finds no appropriated funds within a given category, he may use funds from another category, as long as both categories are in his constitutional purview. Now, this says Vice Chairman Appropriations Committee. Don't be surprised, I disagree. Congress's power of the purse, Article 1, Section 9, I believe constitutes one of the most fundamental and foundational checks and balances on the executive branch. So do you believe the president can ignore Congress appropriations allocations, conditions, and restrictions in law? Just ignore them and take the money and
Not as a general proposition, but that was a
general proposition.
I actually thought that was a good law review article. I gave it as a speech, and it was really a thought piece. And what I was really saying was, and I say right up front, that the more I thought about the appropriations power, the more confused I got. And I was just laying out a potential template, which is this. People frequently say, the power to, spend money on this division or this missile system is part of the power of the purse. And what I was actually saying was, actually what the power being exercised there is the substantive power that Congress has to raise armies. And it's not, it doesn't come from the power of
specific appropriations on agriculture or on defense. For example, could a president just build a wall along our southern border because he wanted to and just take the money, whether appropriate or not? What about eminent domain?
What about eminent domain?
Well, if you're going to build a wall, you got to take a whole lot of land away from landowners in Texas and elsewhere.
Well, you'd have to show me what statute is being invoked and also what appropriations is being used. I can't answer that in the abstract.
So you're saying the president, though, can have the power to go into money even if the Congress is appropriated for a different purpose?
I didn't say that. But some
You mean that?
I don't mean that. I'm saying that there are monies that the president may have power to shift because of statutory authority.
But that would have been because Congress gave him that authority.
Right.
Not because he has it automatically.
I'm not taking that position. As I said, my law review, it was published as a law review article, and it was a thought piece exploring what limits there might be to the appropriations power and where Congress's power comes from in certain areas.
Thank you. Thank you, Mr. Chairman.
Interesting line of questioning there. Quick 60-second commercial break. John Cornyn, we believe, is next on the other side of this.
To the Article 2 powers, the inherent authority of the Commander-in-Chief.
I'd like to take a moment to address my fellow veterans.
Back in.
Once again, as the chief law enforcement officer of the country, thank you for doing that.
Thank you, Senator.
Thank you to your family as well. To me, the Attorney General is one of the most challenging cabinet offices to hold because, as you point out in your opening statement, you are committed to the rule of law and enforcing the laws of the land, but you are also a political appointee of a president. If you are serving another cabinet position, certainly you're committed to implementing the president's agenda or the agenda of an administration, but as Attorney General, that is not an unequivocal commitment, because there may be some things that the administration wants you to do that you cannot do consistent with the rule of law, correct?
That's right, Senator. One of the reasons I ultimately decided that I would accept this position if it was offered to me was because I feel that I'm in a position to be independent. You know, over the years, a lot of people have, some politicians have called me up saying, you know, I'm thinking of going for the Attorney General position in this administration and so forth. And I say, you're crazy. Because if you view yourself as having a political future down the road, don't take the job. Because if you take this job, you have to be ready, you know, to make decisions and spend all your political capital and have no future. Because you have to have that freedom of action. And I feel I'm in a position in life where I can do the right thing and not really care about the consequences, in the sense that I can truly be independent.
Mr. Barr, thinking back about the run-up to the 2016 election, where the nominee of both political parties for President of the United States ended up being investigated by the FBI. Can you think of any precedent in American history where that's occurred that you know of?
No, I can't, Senator.
And thinking back to James Comey's press conference of July the 7th, 2016, where he took the step of talking about the evidence against Mrs. Clinton, talking about the legal standard that would apply as to whether she might or might not be indicted for committing a crime under the Espionage Act. Have you ever seen a situation where an FBI director would usurp the authority of the Department of Justice to make that charging decision and hold a press conference and talk about all of the derogatory information that the investigation had gleaned against a potential defendant, and then say, now we're not going to, no reasonable prosecutor would indict her? Have you ever seen anything like that happen before?
No, I've never seen that, and I thought it was a little bit, more than a little bit. It was weird at the time, but my initial reaction to it was, I think Attorney General Lynch had said something, you know, she was under pressure to recuse herself, I think, because of the so-called tarmac meeting. And I think she said something like she was going to defer to the FBI. Mm-hmm. So my initial reaction to that whole thing was, well, she must have agreed, or it must have been the plan, that he was going to make the decision and go out and announce his decision.
Under the normal rules, if the Attorney General has a conflict of interest,
it would go to the deputy.
It would go to the deputy,
correct,
not to the FBI director to make that decision, correct?
Right, so that's why I thought it was very strange, but I think later it became clearer, to the extent there's anything clear about it, that I don't think Attorney General Lynch had essentially delegated that authority to the director. And I think Jim Comey is as I've said, is a extremely gifted man who's served the country with distinction in many roles. But I thought that to the extent he actually announced a decision was wrong. And the other thing is, if you're not going to indict someone, then you don't stand up there and unload negative information about the person. That's not the way the Department of Justice does business.
I was shocked when Mr. Comey later wrote a letter saying that based on the discovery of Clinton emails on the Wiener laptop, that they were reopening the investigation that he had already announced closed. And then finally, just days before the general election, November the 6th, 2016, said we didn't find anything on the laptop that would change my conclusions based on the press conference of July the 6th. Did you likewise find that to be an extraordinary, I will use the word bizarre, but certainly unprecedented event?
Yeah, the whole sequence was very herky-jerky and bizarre, but at that time I was a little of a contrarian in that I basically took the position that once he did what he did in July and said the thing was over, and then found out it wasn't over, he had no choice but to correct the record. So I said that he had no choice but to do what he did, but it sort of shows you what happens when you start disregarding the normal procedures and established practice, is that you sort of dig yourself a deeper and deeper hole.
Why is it that the Department of Justice rules, which also apply to the FBI, make it clear that our chief law enforcement agencies in this country should not get tangled up in election politics? Are there policies in place that try to insulate the investigations and the decisions